This is the new street that they put in at WSU 19th. The hotel is going on this side. So this whole corner is still vacant. The church that was mentioned earlier is over here. This property over here is the old Kmart building was down here, is now a storage area building. This whole corner over here is really ripe for a grand plan development. However, the city, the DAB and your board and the city council allowed apartments to be built over here. So that takes away from developing this whole corner in a cohesive manner. That's what we argued for before the DAB and before you when that came up about a year and a half ago. So having said all that, just once again reiterate, I'm against the rezoning of this property at this time. Any questions?
Thank you, sir. Do we have any questions for the speaker? Seeing none, thank you for your time. If we could have anybody else who would like to address this item?
Hi, Steve Falke, number 3, Crestview Lakes. This is my home here. I am also the president of the Crestview Lakes Homeowners Association, and yes, a majority of our residents are against any rezoning in our 16 lots. We want to keep it all residential. The challenge is this is completely out of not only our control, but I think largely the city's control. When you have an SF5 zoning with a university overlay really should say carte blanche, and they can do whatever they want. We are trying to take a stand here for the value, as Art said, of open space, green space, property that in the future will be able to maintain its value as a residential location. And we would just ask that you would deny this rezoning. Any questions?
Thank you, Mr. Balking. Any questions? Yes, Mr. Foster.
Has your association been advised about protest petition?
Yeah, we've done protest petitions in the past. We're in the process of doing them now.
Okay.
For all of this zoning.
Any other questions? Seeing none, thank you.
Thank you.
Anybody else that would like to address this item? Seeing none, if we could have the agent or applicant come back. You have 2 minutes for rebuttal.
Again, Russ Avey, agent for the applicant. Just to address some of the civil matters that were mentioned as far as what the obligation of this particular property is to the maintenance and care of the lakes and streets and roads and open space of the neighborhood. You know, I simply can't stand here and give you a definitive answer one way or the other. I would think that if we have a legal obligation to pay our dues, whether it's a commercial endeavor or whether or not it's a residential endeavor, and I'm not sure that that really would matter very much one way or the other. And clearly it's been stated here by staff that the restrictive covenant issue is also a civil matter that really bears no weight on this particular issue at hand here today. Clearly it's something that anybody purchasing the property for development going forward will have to take care of along with the homeowners association in general. I'd like to apologize to Mr. Tolson. I got an email when I got back in town last night that the protective overlay was that he hadn't seen our proposed list of uses that we were going to exclude. So my apologies to the Tolsons. They're the most directly affected by both of these applications, and it was the Tolsons and that the Nielsen's were helping me craft this protective overlay with the mind of their adjoining property owner. So my apologies again to them. I will just simply reiterate, you know, it's one thing to live a football field away. It's one thing to live 3/4 of a mile away and talk about the impact of the neighborhood. I don't think anybody in the audience or listening to me speak would disagree
Mr.
with the
Raby,
fact.
Mr.
Yes.
Raby, your time is up.
10 seconds.
10 seconds.
I'm going to start. No.
2001.
No, I just wanted to make the point that the Nielsen's property bears the brunt of this intersection, of the development around this intersection. And with Crestview Lakes to the west, I think there's a natural break that we can see in the College Hill area, that streets provide that clear break and definition of land use division lines. I'll stand for any questions that you may have.
Do we have any speaker or any questions for the speaker?
Thank you for your time.
Seeing none, thank you, Russ. Okay, we'll bring it back to the commission.
I'd like to make a motion that we close the public hearing and defer our vote until after we hear 00032.
There's a motion to defer to, at this point, December 19th. Do we have a second for that motion? Well, I'll second it. Do we have any discussion on the motion? Mr. Foster?
I'd offer a substitute motion.
Okay.
As we've been, working through this and all the information we've received from both the applicant and the homeowners, just several things. Actually, I've made 5 notes that stand out to me. Number one is the importance of platting in terms of its impact on establishing the character of community going forward. And you can see how long that plat has stood and the impact it's made on the community here. The other is, from that plat, there are 2 things that stand out. One is this property is directly tied to the drainage issue and the lake that it ties to. Something else, just the layout itself. You have those lots that are tied up there along Oliver. This one doesn't relate to those whatsoever. It relates specifically to the character of the lakes and specifically to the single family development. So both drainage and land use wise, I think that would indicate continued character of the single family. 4th item would be relationship to the neighborhood plan. Obviously staff worked hard with the homeowners there to develop a good plan. We should respect that plan, and this application does not meet that plan. Final thought is, highest and best use is not always commercial. In this case, the best use is single family, so I would make a motion to disapprove the application.
Was that Mr. McKay that second? Okay, yeah, Mr. Foster with the substitute motion says to deny completely and keep it as F5, and Mr. McKay second. Mr. Dool, do you have a comment? Bob, you'll need to push your button so we can hear you.
Yeah, Mr. Johnson, I was curious as to what you thought we would gain by deferring this until we hear the other case.
Well, I guess if we heard the other case and we denied it, it'd be easy to deny this one also. And I'm just looking at the possibilities that exist. I have no problem with the substitute motion.
Okay, Mr. Foster?
I do see these as distinct cases. When you study that plat and the testimony about the intersection and things, I think they're distinct cases.
All right, any other comments, discussions? Seeing none, we'll go ahead and bring up the substitute motion to deny and to keep the zoning at SF5. All those in favor of the motion signify by saying aye.
Aye.
All those opposed, say no. Motion carries, substitute motion carries, so the zoning will remain SF5. Now, if we could go back to the agenda, the first item on the agenda is item 2.1. And Tim, going, oh.
Well, you can do it. All right. You ready? All right, some of you have seen this before. It's a little bit repetitive for you, but I'm here to talk to you about the safe field analysis that became a requirement in 2005 for subdivisions platting outside the urban growth area. It was due to major concerns of large-scale growth outside that development area. The City of Wichita, GMD2, and the county came together to look at some kind of regulations for not only wastewater and water supply, but for roads. And I'm here specifically to talk to you today about the water supply requirement. We're looking at, from comments we've received from the development community, is it adequate? Is there a better option, or does it just need to be revised or removed? Safe field analysis in general is a way to determine if there's an adequate water supply to supply, that it's not going to impair existing water rights or any water rights. And it was an addition, originally developed to look at public water supply and large-scale irrigators, so farmers. It basically looks at a 2-mile ring around that point of diversion. It's a geologic done by a geohydrologist. It's basically a computer model to determine whether there's sufficient groundwater there to supply their needs and sufficient recharge and not impinge or deplete that groundwater area and not impinge on any other water rights within that 2-mile ring. Due to the concern with the development, it was decided to do this with the rural developments plats being developed. It's had to be modified somewhat because it doesn't really apply to a domestic residential well. Domestic wells have never been under any kind of a water right requirement, because in the past you had a few farmers and a few rural area residents that lived on water wells, so there's no fear that they're going to deplete a groundwater source. Since the inception of this requirement, things have started to crop up. That you look at the 3 options on the board, that the time it takes to get it done, limited options for getting the analysis done. Currently, there's 2 entities that will produce reports. One's a private entity, one's the groundwater management district. If you're in their district, they will produce a report. The development community also is looking at the cost of the report and what does the report really mean. When you apply it to those large-scale users, it means quite a bit. When you're looking at applying it to domestic water well users, it takes in that particular plat, but it doesn't consider any other domestic wells within that 2-mile ring. So if you're looking at a 20-lot plat, it's going to look at 20 domestic wells in that plat. It's not going to look at if there's another 100 domestic wells within that 2-mile ring. It's not going to consider those. So, the time it takes to get the report back was one of the complaints, and that's kind of, like we said, a double-edged sword, because it's typically the last thing they do before they get their plat final. They don't think about it. The cost of the report is in that range of $1,500 to $2,000. Developers feel that this is an additional burden on them that they don't need to do. And over time, we've started looking at the report more in depth and seeing what it really tells us. And what we've determined is it doesn't tell us a lot. It tells us whether there's enough water in that 2-mile ring, but it doesn't specify whether that water available is under that specific site. So you may have sufficient water available in that 2-mile ring, but under that particular site, you may not have sufficient water, but we don't know that. And examples of that are Hedge Creek Estates and Redmond Estates. We got reports there that there was adequate water to supply the subdivisions. Several of the lots had trouble finding enough water to supply household needs. So, you know, what we talked about earlier is it doesn't take into account all the different domestic wells. So in this picture, you're looking at 3 different subdivisions overlapping each other with 2-mile rings. However, when that report was done, they only applied that 2-mile ring to that particular subdivision. So one subdivision had 37 lots, another one had 32 lots, but they only looked at that particular 32 lots. Within that area, it's estimated that there's 177 domestic wells, and it didn't look at all 177 of those. And trying to compare what we think a rural resident uses, we did some calculations, and you know, if you're looking at 450 gallons a day per residence, which is typically a 3-bedroom residence, and you do all the calculations, they use approximately 89.21 acre feet per year, which is about, for a center pivot, 130 acre feet per year is about average. So we're not approaching that tipping point where we're impinging on a potential irrigator who may want to come in and get a water right. You know, if you bump it up to 600 gallons a day, you then look at 91% of that pivot use. What this basically looks at, a couple of things. It looks at just residential use inside that residence. It doesn't take into account irrigation use because there's no way to account for that. We don't put meters on residential wells. So in actuality, we don't know how much they're using, especially on the irrigation side. You know, what we see is in our current form, we're not getting any real-time data to help us out that's going to ensure a buyer of a lot that he's going to get sufficient water to run his household. So do we want to, you know, options to pursue, or what we're talking about is doing some type of more in-depth safe yield. We don't know that that's adequate or not either. You know, you can coordinate and get some more studies done, whether it's KU School of Medicine, who's just done some domestic well testing and stuff, or require wells to be placed, test wells to be done on lots, and if placed correctly, could be sold to lots, or do we eliminate this requirement altogether? Go back to buyer beware. Buyer needs to be educated. This is one example we could go to in the approval memo we have to write for a plat, that water wells are approved for use. However, there's no guarantee of quantity or quality. Test wells are recommended. You know, we've also talked to the state water well director of the well program, as well as the Kansas Geological Survey. Their conclusion is you're not going to get a sufficient study done to determine that. The only way to really determine if you're going to get water is to drill a well on that lot. So from MAPC standpoint, we feel like that it's time for this, what we thought was an appropriate action, to go away and go back to buyer beware. Because there's no real way to guarantee, there's just not a way to guarantee that water's going to be there. Any questions?
Do we have any questions, Mr. Foster?
Tim, I've made 4 notes here. The first one is on that Hedge Creek Estates and the Redmond Estates. What was the outcome of that where water was not found?
They finally did find water. I don't know exactly how much they found, but, you know, what we've been told, that, you know, initially I thought it was at least 15 gallons to make a good household. They said anywhere between 10 and 12 will run a household. It may not be the best case scenario because you may not be able to run 2 showers at once, or you may not be able to run the washing machine and the shower at once, but they can do it. 15 to 20 gallons would be more sufficient. They did find water there. We just don't know. We don't know what the outcome as far as quality and quantity was.
Second item is regarding irrigation water. Would you consider that going in great proportion going back to the aquifer anyway, therefore keeping track of it really doesn't matter? Or attempting to try to include it in an equation is irrelevant?
Possibly, but when you drive around and look, there's a lot of water waste going down in ditches.
But doesn't that eventually end up in a body of water of some sort?
Potentially, it may not be within that 2-mile ring. So,
I'm thinking of the distinction between a house where it's contained, it's going to go either into sewer or somehow, you know, it's piped, so to speak. Correct. Yeah. Third item is, since this was discussed at the subdivision level, has there been discussion, because the big concern was the buyer beware seems a little short-sighted in the sense that, I know I made the comment, it's like selling a car with no engine if you don't know if it doesn't have water. What has been discussed since that subdivision meeting?
Like I said on one of the previous slides, I've talked with the director of the state water well program and also with Kansas Geological Survey, who keeps track of the water well records, drilling records. And they say there's no real way to, like I said, no real way to guarantee there's going to be water available on that particular lot unless you drill that well on that lot. So I don't know. I mean, do you want to go to that extreme where you're going to make the developer plat, as they plat, or be able to prove that there's water for that potential buyer?
I'm just curious if there's a broader think of it for the real estate industry and perhaps developers, if things have happened around in other states that might be looked into.
Not that I'm aware of, but we do some more checking.
Mr. Richardson?
Tim, just to be clear here, this is not in any way to manage the groundwater or the aquifer supply. This doesn't apply to farmers that want to irrigate with center pivots or any of that sort of thing. Is that right?
Our particular regulation does not. The safe yield analysis does by state requirement.
But
But ours does not. Ours is just looking at domestic wells only.
And does it in some way affect the farmer's ability to be able to use that water? These are mutually exclusive, are they not?
That's correct.
We don't see this being a plat being denied because it's going to impinge on a farmer's water rights.
We don't even look at that.
We don't even look at that. Okay. Just to be clear, we're not managing the groundwater supply here in any way. We're simply saying we think there's a domestic water available or it is not.
Correct.
For homes. And then
correct.
How does this process work? Does every plat require this or just of a certain size plat?
Plats more than 1 acre or one lot in size are required to do it outside the urban growth area. Within the urban growth area, they're not required to do it.
Okay, so everybody has to do it, so it's a burden on everyone that does it. Do these ever come back with a negative, and therefore, you know, at what point does this apply to the platting process? We've never heard this in the subdivision committee in the 5 years that I've been on it. Does a subdivision ever not get approved because there's not a safe yield analysis that says there's water there?
Has not yet.
So the question is, why do we do these if all the plats get approved? Can you build a scenario which says this plat's not going to be approved because there was not someplace in that 2 mile ring we're going to find water, right? I mean,
possible. I don't know. It's possible that if there's an appropriate area that's over appropriated and they find out that that's a possibility.
So every safe yield analysis so far has come back and said, yeah, there's water there.
Correct. And every geohydrologist that's done one says it's a waste of time for domestic use.
Okay, so as a practical matter, we've never had a plat not approved because we had a negative safe yield analysis.
Correct.
Okay. All right, so again, we're simply looking at individual lot use. We're not managing the aquifer here. We're simply saying we think somewhere within 2 miles there may be water. Good luck finding it. Back to the next issue, which is, it's going to be really hard, it seems to me, to put, you can put this on the plat that says you need a test well. You can put it in the title work. Unfortunately, folks who buy these things never read the title work as long as the loan officer says it's okay. Do you have a suggestion any other ideas as to how we do something besides simply throw our hands up in the air and say, buyer beware?
I currently don't. I don't have a better suggestion. I don't think there's no better scientific evidence out there to do something. There may be, but it may cost tens of thousands of dollars rather than a few $1,000s.
I have one other question, which would be really for staff, is that are we we being the city, the county, under some obligation to provide information to plats that have gone through that says, yes, this can be developed in because there's water and sewer available? I mean, it's almost like saying, is electricity available?
Do you want to say something first, Dale?
Well, I was only going to say that from memory, and John or some of the other people have been around as long as I have may remember, but I think this was sometime in the 90s, that particularly southeast, we had a developer or two that I haven't heard about for a long time that was selling rural lots, and they had no water. And so it was brought to the commission's attention that how in the world can you be approving lots, like you said, where there's no water, we can't do anything. And so that's how this policy was developed. We've been going from there. The only thing I would add, and I assume Tim has thought about this, and it probably would cost a ton of money, is instead of just doing the within 2 miles, if you had a requirement that they had to drill on a lot in the plat and see whether water's there or not, or every 10 lots or whatever, but that's just a thought. But Dave has more information about whether there's any legal requirement for us to do that.
I'm
who would be responsible?
Go ahead.
Who would be responsible to drill that, the developer or the lot owner?
Well, I would assume it would be the developer, but that's up to the commission to develop the policy.
And what I have to share with you covers that issue on point. Got two things to talk. One, there is actually a case that came out of Butler County back in, I think, the 70s, called Dings versus Butler County. The summary there was an 80-acre piece of property that the Mr. Dings was attempting to plat into a series of lots. The case would tell me how many lots. I don't remember it off the top of my head, but it was 20, 25 lots. The county ultimately denied the plat because he refused to even find out whether there was water available. He had neighbors that had existing homes that had water issues with their own homes, and they said there's no way they'll provide water, and rural water was not available at that location at that time. The plat was denied. Mr. Dings sued. It ended up going all the way, as I recall, to the Supreme Court. And the conclusion was, from that court case, was directed to the county. Yes, you have the authority and the ability under law to deny the plat if you're not able to prove that there's adequate water to support the lots. And they went the next step, and the court said basically to the county, vis-a-vis through the planning commission, you have an obligation to determine you have adequacy of water, and it's almost, if you will, wrong for you to not take that into account. So there's a court case out of the Supreme Court of Kansas that really kind of charges local communities to at least evaluate the availability of water when you're in rural areas where you don't have a public water supply available. Now, what Tim is saying is that the safe yield analysis really doesn't do the job, and that kind of went to Lauren's question, or Mr. Richards' question earlier on. Second thing, we did do it at one point through the process of platting in Butler County when I was on staff there. We were required, with a plat, a submittal of a quantity and quality analysis for water. And there was a testing of wells, and we used, I think, one every 5 lots, maybe 10 lots, I don't recall. And we actually had some people that did that. And it was required to not only determine that there was adequate quantity, which essentially was a drawdown and a recharge timing test to determine how rapidly you could get water to recharge back into the well. But we also required a quality analysis because we knew very well that we had some water. Yeah, you might be able to get water, but you were having all kinds of problems because it was very hard water, and there were other issues that could arise that needed to be addressed. And the Planning Commission and the County Commission at that time there felt it was an obligation to at least provide that information available if we were going to approve the plat. Now, whether they're still doing that in Butler County, I don't know. And I'm aware other counties have done the similar things when you're talking in rural areas where there are not public water supply available. And one of the things that we had over in Butler County that made it easier was there had been so many rural waters districts established and lines extended that their public water was generally available over there on huge areas, which was truly driven by the development community and the real estate community because they were aware of water history problems that made it difficult to sell rural property. So I share that with you only from the standpoint of saying that I think that the law, the statutes basically say the obligation is there needs to be an analysis done. I don't have available today an answer. Secondly would be probably a discussion that ought to be held of other methodologies that would at least beginning to address water issues on the area that's being proposed to be platted. And worst case scenario, if we didn't do that and we went to truly, and I'm not beating on Tim, but it was a true buyer beware issue, and we have like another issue coming where you got somebody with lots that expended money and there's no water available. And does it leave the county open to subsequent lawsuit of neglect because we approved the lots in the first place when didn't even know there was water there? So I just share that with you.
Mr. McKay?
Dale, I remember it's been a while back in the northeast part. It's all being developed now because it's in the city. But we turned down a plat. There's 5 houses on like 40 acres a lot, 40 acres, and they could not provide water either for fire protection or for sewage or any of that because the ground would not perk or anything. And we denied that plat. Now, I don't know if that has any bearing on what this is. I can't understand what this is all about. I mean, I'm serious.
As best
I'm
I
kind
understand.
of a rookie at this, but I'm still saying that I don't quite understand because the reference was used to a 30-some unit subdivision. That's a whole lot different than 1 or 2 houses out in the deal. And if you got a 2-mile ring, who's going to pay to get it? If you find a well a mile away, who's going to pay to get that over to you for your subdivision? And I think the marketplace, the one you're referring to down southeast, the marketplace took care of that situation.
I think what Tim is saying is that in order to satisfy the requirement of the safe yield analysis, instead of requiring a well to be drilled on the plat, they can use the existing wells in the area, and if the existing wells show that there is water available, then the assumption is there's water available for the plat, the proposed plat, and that meets the requirement. Is that accurate, Tim?
Close. I mean, the safe yield analysis is a little convoluted. It's basically a model where they look at the geologic hydrology and everything under there and determine what the recharge rate is on that piece of property versus what the potential withdrawal is. What they don't take into account is as you develop that property, the recharge rate goes down because now you've developed hard surfaces and most of it's going to run off.
And so what his point is, the way we're doing it now doesn't really guarantee anybody that they actually are going to have water on a specific lot. And he's just bringing it up as, do we need to get rid of this and stop requiring that because of the time lag and the expense? Or does the commission feel like that we need to look at a different policy and do more work on a more specific policy?
Well, has this become a problem, or is this just something that we think might happen?
I don't know that it's so much a problem, more than it's just a waste. It's not telling us anything. It's a report that's being generated for several $1,000s. It doesn't tell us anything, really.
Mr. Dool and then Mr. Blick. Hey, Bob, could you push the little red button there?
The assumption is, I don't think the assumption is valid because there's water within a mile from you that there's going to be any water underneath you. I mean, we all know those aquifers don't flow in an even depth. So I think this whole thing is ludicrous.
Well, it is originally applied to big irrigators and public water supplies where their drawdown is a lot larger area. That's why the 2 mile ring, because they've got a large drawdown versus a domestic well that has very little drawdown.
Mr. Blick?
The verses of the burden is now on safe yield. So if someone does say there was water, you can come back and say, well, self-yield said within 2 miles there was water. But if we get rid of this, where's the burden fall back onto? And that's basically what you were saying earlier is.
Correct. Unfortunately, when you become a rural homeowner, you become your water supplier, you become your wastewater supplier, and you need to take care of both.
Mr. Richardson?
Well, I think it's perfectly clear this doesn't provide any guarantee at all that there's water there. My concern is we get rid of this, do we still have an obligation? And I would like for the staff, and I'm sorry the attorneys have gone here, because I think maybe they left on purpose, I'm not sure. But I think they need to go back and study this issue and say, number one, do we have an obligation with regards to water? I mean, when we approve plats, we say you've got to get the percolation test for sewers and all that sort of thing, and if it doesn't work, you can't build there. Seems to me like there needs to be something said about water. So I think this doesn't work, but I'd be reluctant to do that. So, I would move that we instruct the staff and the legal staff to, number one, look at, do we have a requirement as the county to provide some comfort as to, and comfort's not a legal word over here, but some guarantees or some analysis with regards to water supply. And secondly, if the answer to that's yes, what would their suggestions be as to how we do that? And I would make that in the form of a motion if that's what we're looking for. Is that what we're looking for?
I'll second.
Mr. Richardson made the motion and everybody seconded it. Put that in your minutes.
Therefore, no vote is required.
No, Mr. Richardson, I think that makes a lot of sense. We obviously need to find out the answer to both of those, and before we can move forward in any kind of fashion. So with that being said, yes, Mr. Foster, do you have a comment on the motion?
I would like to actually add to that. I think it'd be important for us to hear from the real estate industry, any comments that staff could track down. I think that would be important for the discussion.
Yeah, I would assume that they would do that as part of their research.
Mr. McKay?
Well, Dale remembers when we did the comprehensive plan 3 or 4 years, and so does Cindy. We covered this at length because it wasn't This wasn't the problem. It was the rural water districts encroaching in on what we were doing. So you're going to have the same situation going the other direction. So, you know, what effect is the rural water districts going to have on this? That's just part of the criteria. And it may be, like Dave said, we may just have to require, you got to show us that you've got water available. Now, that's different than a subdivision. To me, that's two separate worlds. You know, if you have more than like 3 or 4 houses in one deal, that's a different thing than having 5 to 10 houses, or even going to 30 houses out in the county. There must be, you know, some way down the line, the marketplace will take care of it, but somebody might get burned before the marketplace takes care of it. That's the biggest problem.
Okay. Any other comments, questions on the motion? All those in favor of Ms. Miles? All those in favor of the motion signify by saying aye.
Aye.
All those opposed, nay. Motion carries unanimously. That's the end of our meeting. Thank you.